Right from the jump, notice how the judge is sorting out who's present. These early roll calls might seem boring, but they set the tone, especially when a defendant is facing a potential revocation. Keep an eye on how formalities suddenly turn into life-changing decisions.
All right, who's here on Candace Cox?
Right, Judge.
All right.
Don't remember what side I'm on, Judge.
Oh, this side. That was a move that was requested by the deputies for security reasons, because defense attorneys were on this side. All right, the court is calling 2022 CR 5387, State versus Candace Cox. Can I have parties announced?
Melissa Albin for the state.
Scott Hill for the defendant, Ms. Cox.
Defense, can you ask them to move down there, the attorney? Thank you. All right, we're back on the record. And you're our Ms. Cox?
Yes.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Quick pause going off the record usually means the judge or attorneys need to discuss something privately. It's never a good sign for the defendant because what comes next is often the turning point.
Did you understand it?
Yes.
Are you the same Candace Leah Cox who was placed on deferred adjudication in 2022 CR 5387 for the offense of possession of a controlled substance? All right, we're going to go off the record.
This amendment matters. Penalty Group 1 less than a gram is still a serious Texas drug charge. Even tiny amounts can lead to felony consequences. What seems like a small correction on paper can drastically change the legal impact.
All right. With regards to the motion to enter adjudication of guilt and revoke community supervision, any requests from the state?
Yes, Your Honor, we'd like to make an oral amendment to the allegations as far as the offense that she was placed on probation for. It should read possession of a controlled substance, penalty group 1 less than 1 gram.
Any objection?
No objection, Judge.
All right, Ms. Cox, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Candace Lee Cox.
All right, Ms. Cox, the state is requesting an amendment to the motion to enter adjudication of guilt and revoke community supervision. They're asking that it be amended to include the words possession of a controlled substance, penalty group 1 less than 1 gram. That's a substantive change. Do you have any objection to continuing with that change?
No.
All right. And are you waiving notice?
Yes.
All right. State, you may proceed.
Your Honor, we'll proceed on violation of condition number 41, the last condition. On or about the 21st day of February 2023 in Bexar County, Texas, the defendant, Candace Leah Cox, then and there failed to comply with the rules and regulations of the felony drug court in that the probationer absconded and illegally removed their GPS wand.
And here it is, the violation. Removing a GPS monitor is one of the most severe probation violations you can commit. Judges see it as absconding, which means running from supervision. At this point, Candace's options shrink dramatically.
This is in violation of condition number 41.
How do you plead to that, true or not true?
We'll waive the rest, Your Honor.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 41?
Yes.
Court will find violation of condition number 41 true. Is there a proposed agreement?
There's not an agreement, Your Honor. We're recommending revocation in 1 year in the state jail, and I think Mr. Hill is asking for something different.
Yes.
Judge, I can put her on as a witness as well as her mother, but just to give you the Cliff Notes version right now, her mom, she had a serious drug issue back when she took this plea back in, I think, early 2023.
Mhm.
Her mother, who is Miss Juanita Garcia in the wheelchair there, to protect her daughter, who was 6 at the time, moved her and her husband sitting right behind her,
Mhm.
moved down to Corpus Christi and took her daughter.
Mhm.
She could not be without her daughter. So she did something she shouldn't have done, and she understands that.
When you say she could not be without her daughter, are you talking about your client's daughter?
Yes, Judge.
Okay.
So irrationally, she admits that she made a mistake. She just moved down there, and her daughter was 6 at the time. She didn't want to lose contact with her. Now, her mother did that to protect her 6-year-old because she had a drug issue at that time. When she moved down there, her fiance went with her. Not too long after that, her fiance passed away in her arms, had a heart attack, and that has completely just changed her. She's not doing drugs anymore, Judge. And a fate of irony, Judge.
Listen to this emotional pivot. The defense is painting a full picture narrative. Addiction, parenting, tragedy, recovery. This is a classic mitigation strategy. But will the judge buy it? Or will the prior absconding outweigh everything?
Her disobeying and breaking the conditions of her probation has actually propelled her. Not that it has anything to do with that, but she found herself, Judge. She got help. She's been clean for over a year. She's solely responsible for taking care of her parents and her 9-year-old daughter. So everything is going great in court. Now that doesn't. I'm hoping that the court will consider, because she's doing so good right now, and you can hear from her mother in a second if they need to extend her probation and maybe transfer it down there. She's happy to do whatever the court wants her to do, but sending her, she knows she deserves to probably do a little time for what she did. But I think that in the long run, it's going to hurt her mom and her dad and her daughter even more, to the point where the state will probably take custody of the daughter because the grandparents aren't physically able to take care of her. So those are the issues I want to do. And if you need to hear from some witnesses, I'm happy to put them on.
All right, well, what I can tell you, here's my issue. Number one, I don't know if you've been cleaned or not because you didn't report. I don't understand why you would cut off your GPS and leave Bexar County when I know that felony drug court would have addressed those issues with you. So what have you done on probation other than cut off your GPS monitor and leave to go live with your mom when your mom removed your daughter from this situation because you have a drug addiction? So what have you done?
I've just been taking care of them.
No. What have you done on probation?
I've made a visit,
Judge, I think
visited with the probation officer.
she had one visit. It happened like right after she was put on deferred, Judge. I think she had one.
This is the moment everything collapses. The judge isn't convinced. In probation court, actions matter more than promises, and cutting off GPS is almost always a deal breaker. This is why courtroom decisions can feel brutally final.
Visit, and then she left.
Okay, that's a problem. I mean, because felony drug court is there to help you, and what you just pled to is you removed your GPS monitor and you absconded, and you were on probation. And what you did was you took up a space that somebody else could have had, because felony drug court, they're always at capacity because it's a very good program and it's to help people with drug addictions. So basically what you did was you cut off your monitor after your parents had left. And the reason why your parents left and took your daughter with them is because you were not an appropriate person to be around a 6-year-old. So what did you do? With your drug addiction, you cut off your GPS and then you left. I'm not going to continue you. I'm going to grant the motion and I'm going to find you guilty. I'm going to sentence you to 2 years in the state jail facility, give you credit for any time served. There's to be no unsupervised contact with minors, and I'm going to recommend the therapeutic community. I'll retain jurisdiction. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.